My name is Bob Eitel. I'm from the Defense of Freedom Institute. We are interested in issues of civil rights, particularly in the education context, education freedom, and other school-related issues. We focus on federal policy, and the reason I'm here today is because I had the pleasure of working for Secretary Betsy DeVos during the last administration, handling a number of issues, including regulatory issues, particularly Title IX, and was one of the architects of the Title IX regulation that was passed in 2020 that corrected some of the outrageous decision-making from the Obama administration. I'm going to talk to you about sort of, whereas Colin spoke to you about sort of the scientific issues, and Leora talked about the medical issues. I'm going to talk about the legal aspects of the cultural conflict over gender identity, and specifically how a federal law known as Title IX is being used by the Biden administration as a vehicle to impose radical and social change in American society using America's schools. So these issues that you've just heard discussed will leave the sort of the arena of discussion and discretion and sort of voluntary behavior and find their way into America's public schools as a legal mandate. And I'm going to get into that and explain why. This current legal effort, epitomized by the Title IX rulemaking effort, is the culmination of decades of work by the left that started in the academy years ago and has slowly crept into American institutions and corporations. And you think you've gotten a sense of that today through the other speakers. So what I thought I'd do is give you a little bit of a brief overview of what exactly is Title IX, talk about some of the changes that the Biden administration is seeking to impose through Title IX, and then explain to you as a private school parent or teacher or student why this is still very important to you. Because Title IX does not directly regulate private schools, although it does have an impact. So Title IX is a federal law that was passed by Congress and signed by President Richard Nixon in 1972 that does a very simple thing, and that is it bars discrimination on the basis of sex, and it uses just that language, sex. The words gender identity are not in the statute. And it specifically does so by schools, colleges, and universities that accept federal funds. So any school, college, institution of higher education that participates in Pell Grants or student loans or receives research grants, funding for public K-12, you're covered. The law, interestingly, passed on a bipartisan basis with clear majorities in both chambers and in both parties. It was very much a consensus act. I will say that since we're in Massachusetts, I have to mention that Ted Kennedy, when he was a senator for Massachusetts, was sitting in the Senate. He voted for the bill in the Senate, but when the bill came back from a House-Senate conference, he voted against it. And anybody know why? Any idea? Because there is an anti-busing amendment that was attached to the bill that liberals absolutely loathed. So on final passage, you have people like Ted Kennedy and other liberal senators voting against Title IX because there was an anti-busing amendment which actually soaked up much of the attention during the debate. And they ended up voting against it. So and then you had conservatives like Russell Long of Louisiana and Strom Thurmond of South Carolina who ended up voting for Title IX on final passage. It's just an interesting quirk of history. Most people associate Title IX with equality in athletics, but it is much more than that. It applies to any educational program or activity as long as the school or the institution or program, educational program, receives federal financial assistance of any kind. So this covers extracurricular activities, the distribution of financial aid, enrollment in educational programs, majors, degrees, the use of discipline, how grading is done, classroom assignments, recruiting, admissions, and even housing if applicable, even in the K-12 context. It also, based on case law that developed over the years, prohibits sexual harassment within schools. So last July, the Biden administration published a set of proposed regulations on Title IX. And the purpose of this effort is to harness America's schools into making permanent the revolutionary changes about gender identity advocated by the cultural left, sort of the issues that Leora and Colin have spoken about. I have to admit, last summer when I read the Biden administration's proposed Title IX regulations, my heart sank. They are a complete overhaul of the groundbreaking reforms made by Secretary DeVos in 2020. And while the 2020 rule remains the law of the land until the Biden administration publishes a final rule under Title IX, the prospect of change is likely because we're looking at a new rule being published by the Biden administration next year. The DeVos rule included a slew of critically important reforms under Title IX that I'd just like to explain to you so you can kind of put this in context. The DeVos rule that was passed in 2020 does not address issues of gender identity. It was very clear to say that it applied issues solely of sex as a binary biological matter. What it did do is that it reversed some of the policies enforced by the Obama administration regarding the scope of sexual harassment and the issues of how a instance of sexual harassment on campus is investigated. There was something called the single investigator model that the Obama administration pushed on schools, which allowed for a single Title IX coordinator, which is the person responsible for the administration of Title IX on campus, to act as kind of this grand inquisitor that took on the roles of policeman, prosecutor, judge, and jury to investigate, hear, and decide complaints of sexual harassment. The DeVos rule also included a number of important reforms regarding due process requirements. They were particularly important in the higher ed context. So I'm not going to go into those, but suffice it to say that the DeVos rule is a watershed reform. So the Biden administration is moving to kill these reforms regarding due process, but also to do much more. And it really is hard to underestimate the profoundly militant nature of the Biden administration's proposed rule on Title IX and how it mangles the statute, which is a law expressly meant to ensure equal educational opportunities for women and girls based on their biological sex as a binary matter. The proposed rule is a mutation of Title IX unimagined in 1972 when Title IX became law. And I would wager that Senators Thurmond and Russell Long and others had no idea that they were actually voting for a gender identity protections, anti-discrimination statute in 1972, and that President Richard Nixon understood that this was an issue of queer theory that he was addressing when he signed the bill. So let me just go through how some of the highlights of how the administration is seeking to sort of warp Title IX. First, they want to change the meaning of sex by expanding the scope of discrimination on the basis of sex under Title IX to include discrimination on the basis of gender identity. The proposed rule simply extends Title IX to cover gender identity as a class. there's nothing in the statute, there's nothing in the written words of the statute, there's nothing in the legislative history, there's nothing in the intent and spirit of the law that says that gender identity is protected by Title IX. And in fact, after hearing these gentlemen, I'm not sure I know what gender identity is. It's undefined in the proposed reg. There's no reference to how it should be defined. Are we simply talking about transgendered individuals? Are we talking about pansexual individuals? Does it cover binary? Does it cover non-binary? Does it cover asexual issues of gender identification? Is it simply a matter of being queer, whatever that is? I'm still not sure what that is, but it's completely undefined. So this means that your neighborhood K-12 school will, as a matter of law, as a matter of regulation, will have to affirm a child's gender identity regardless of biological sex, to allow biological boys who say they identify as girls to compete in girls' sports, to allow such boys to share locker rooms, share all facilities, and dorms with girls, all without the approval or notification of a child's parents. There is nothing in the regulation, proposed regulation, that requires any kind of parental notification or approval mechanism at all. The second thing that the proposed regulation does is it seeks to widen what the definition of sexual harassment is. And I should say, rather than sexual harassment, we're now talking about gender identity harassment under Title IX, to make it so broad that it can cover any conduct that happens in a classroom or athletic field or at school generally. So what they've done is that they have rewritten the legal standard that's in the current DeVos rule for deciding what is sexual harassment, so that pretty much any type of minimal de minimis conduct by a principal or a teacher or a student that infringes upon the gender identity of a student will be considered gender identity harassment. And so if I were to come over and tap Joanne on the shoulder here, that's de minimis. That is a minimal contact, minimal mistreatment toward a student, a transgendered student. It will require school officials to police all sorts of issues, such as the dead naming that you've heard about, the misuse of pronouns, the mispronouncing. That will become an instance of gender identity discrimination. It will, I can tell you, result in mandatory counseling for the offender, and will give rise to all sorts of Title IX complaints and potential liabilities for schools. Schools will require students and teachers to use preferred pronouns and effectively renounce biological reality. And I'm sorry to tell Jeremy Adams that your stack of stuff that you're responsible for is going to get much higher. So the third thing that you should know about this regulation is, and this goes to James Lindsay's point earlier today, is how Title IX coordinators will be used in school district schools and in higher ed. Under Title IX, since 1975, there's been a regulatory requirement that a school district educational institution maintain what's called a Title IX coordinator, and that person's there to accept complaints, provide education about what Title IX offers, handle complaints of sexual harassment. The proposed rule from the Biden Education Department essentially turns these Title IX coordinators into campus commissars. And I think that the use of the word commissars, as James used earlier today, is well put. It will force these Title IX coordinators to monitor very closely the conduct and speech of students, teachers, and staff while acting as kind of a roving patrolman looking for violations of the regulations. And rather than simply allow for the Title IX coordinators to receive and act on complaints filed by persons alleging violations of Title IX, the Biden rule would turn every school employee into an informant, as it requires them to notify the Title IX coordinator when that employee has information about conduct that might constitute discrimination based on gender identity. So Jeremy, as a teacher, will have the responsibility not only to, if he observes an instance of gender identity discrimination or harassment on the playground, he's going to have to not only intervene to deal with that issue, but has a responsibility to report it to the Title IX coordinator for his school. And if he doesn't do it, the teacher next door, he sees him not reporting it, is going to have to do this. He's going to have to report Jeremy as someone who violates Title IX for not making the report in the first place. It is Stasi-like in its quality. This proposed regulation will effectively disallow any school policy that recognizes sex as binary and biological. Any violation by the school will result in a complaint being filed with the Office of Civil Rights at the Department of Education, investigation by the Office of Civil Rights of the school and the school district, potentially federal court litigation brought by students, and it will place at risk federal funding. In short, it will bring the full power of the federal government, including the Department of Justice and the Office of Civil Rights of the Education Department, upon schools that refuse to go along. Now, you're probably asking yourself, Title IX only applies to public schools. Why should I care? I'm a private school parent. I have sent my child to a private school to get away from this kind of thing. Well, I'll tell you, there's several reasons why you should care. First, Title IX actually applies to private schools in certain circumstances. If your child attends a private school that, for instance, participates in a U.S. Department of Agriculture free breakfast and lunch program, as many parochial schools do, you're covered. If your school has received a special grant for physical improvements or, say, information technology improvements, it's covered. Federal grant or federal money for remedial education or special education for your students, you're covered. If you get a federal grant for opportunities for low-income students that attend your private school, you're covered. So it is an issue that you need to pay attention to. The second thing is, remember this, Title IX covers not just public schools and public universities and colleges, but any college or university that participates in the student loan program or Pell Grants or gets a research grant from the National Institutes of Health or some other federal agency. So if you want your son or daughter to go to Harvard or MIT or Georgetown or Boston College, you're covered. You're going to have to be dealing with these issues up the road, so you should be mindful of them now. But I think the most important reason why these provisions are important for you, even if you attend a private school, is this. Legal standards play a critical role in establishing social norms. That is, what is legal becomes accepted by society, the new norm. This goes, I think, to some issues we've seen now, recently, where certain behavior or conduct has been legalized. So take marijuana legalization. So 10 or 15 years ago, it was illegal almost everywhere. Or frankly, it wasn't socially acceptable to smoke it in public. Not anymore. I was in downtown DC last week. It smells like one big bong. I haven't been out in the streets of Boston, but I have an expectation I'm going to have the pungent aroma of weed in my nostrils at some point during the time I'm outside walking the streets. So Another example would be this, and sometimes this legalization leading to social acceptance results in a good effect for society. So take the Civil Rights Act of 1964, which discriminated on the basis of race. Excuse me, which prohibited discrimination on the basis of race. I would argue in the mid-60s that there was a huge swath of the United States that did not accept the principle that there should be no discrimination based on race in matters of private employment and education. Parts of the American South, urban neighborhoods in the North, the West Coast, probably didn't accept that notion. But I would say that 58 years later, I would defy you to find any place in the United States where it's socially and culturally acceptable to discriminate against African Americans because of their race. Quite rightly, the only acceptable position today is one of racial equality, and that is the way it should be. Now, interestingly, from the left, we've had the rise of the anti-racism and equity movements, which have been discussed today, which seems to be disturbing sort of this consensus that has lasted for half a century over racial discrimination, and that deserves its own discussion, which it received today. But the Civil Rights Act, I think, is an example of how the law can be used for social betterment to make certain behavior not just illegal, but socially and culturally unacceptable in a good way. I would argue that something similar is happening with gender identity in Title IX. The notion is to extend the law to prohibit gender identity discrimination and thereby normalize, to make broadly accepted, the T in LGBTQ. They want, that is the left, want to make it not just illegal but socially unacceptable to oppose any notion of transgenderism, the teaching of gender identity in primary school, or the use of so-called gender-affirming pronouns, or gender-affirming school services, or surgery for teenage girls. So when this rule becomes effective, and you begin to see widespread enforcement, with schools, public schools being investigated, sued, and entering into settlements, or agreeing to resolution agreements with the Department of Education, what will happen in your private school is that you will begin to hear things like, we have to recognize transgender status because it is illegal elsewhere, that's the norm. We can't be an outlier because of reputational risk and the like. You're already beginning to see it in government and corporate America. It's already happening in some schools anyway, but you can see what the game is ultimately about. So, what's next with Title IX? I'm pleased to say that the proposed regulation that was published last July has received a massive pushback from the American people. It may be a bridge too far for them, we'll see. The administration received over 240,000 public comments on its proposed regulations. That is a record for a proposed rule from the Education Department. Actually more than double the previous record holder, which was the 2020 rule. They are under a legal responsibility under the Administrative Procedures Act to read each comment and respond to each of the issues raised in the comments and to publish a final rule at some point in the future. I think that this will probably happen, certainly happen in 2023. I think that they want that is the Biden administration, I think that they want for the rule to become effective for the 23-24 academic year. That means that they will want to publish by late spring of 23, summer at the latest, so it can be effective in the fall of 23. But it could take longer than that. 240,000 comments is quite a bit. In any event, this is something that bears monitoring. I do think, and I am somewhat mildly optimistic, that state attorney generals and schools, private citizens will file a lawsuit trying to enjoin and stop the rule, but a final decision on the merits of the cases could take years. In the interim, I think that the next conservative president will certainly direct the Education Department to revamp any rule that the Biden administration does. At the end of the day, these are issues that Congress needs to face up to and resolve. But one thing is for sure, these disputes under Title IX are really not disputes over education law and policy. They're really fundamental cultural conflicts finding themselves in legal disputes concerning the nature of the individual, the self, family, and society.